the Clerk of Court please call the matter at hand?
Yes, Your Honor. Today is the continuation of the oral arguments in GR number 234359, Eileen Armora et al. Versus Director General Ronald de la Rosa et al. And GR number 234484, Sister Maria Juanita R. Daño, RGS, RSW et al. Versus the Philippine National Police, represented by PDG Ronald de la Rosa, Chief, Philippine National Police et al. Appearing as counsel for petitioners in GR number 234359 are the following. We have Attorney Jose Manuel I. Jocno, Attorney Alexander Padilla, Attorney Felix J. Marinas Jr. Appearing as counsel for petitioners in GR number 234484, we have Attorney Joel Ruiz Butuyan, Attorney Roger R. Rayel, Attorney Gilbert Teruel Andres, Attorney GPA Gonzalez, Attorney Ethel C. Abisado, Attorney Charmaine C. Garcia, Attorney Cristina I. Antonio, Attorney Gil Anthony E. Aquino, and Attorney Crispin Francis M. Handusay. Appearing as counsel for public respondents, we have from the Office of the Solicitor General, we have Solicitor General Jose C. Calida, Assistant Solicitor General Renan E. Ramos, Assistant Solicitor General Rex Bernardo L. Pascual, Assistant Solicitor General Maria Cielo C. Rondain, Assistant Solicitor General Mirna N. Agno Canuto, Assistant Solicitor General Marisa Macaray Guillen. Pursuant to the directive of the court in the hearing of November 21, 2017, Your Honor, we have the public respondents. PNP Director General Ronaldo Bato de la Rosa, DILG Officer in Charge Catalino S. Cuy, Philippine Drug Enforcement Agency Director General Aaron N. Aquino, Officer in Charge of the Dangerous Dogs Board, Jose Marlo Pedregosa. We have Chairperson of the National Police Commission, we have Attorney Rogelio Cazorao, and PNP Internal Affairs Service, Attorney Alfigar Triambulo. Thank you, Your Honors.
Attorney Anama, can you repeat the name again of the Inspector General of the PNP Internal Affairs Service?
From the PNP Internal Affairs Service, Your Honor, we have Attorney Alfigar Triambulo.
Triangulo? Can you give me the name, please? Okay. Thank you. May I just request the counsel for the public respondents and the invited resource persons to please take their seats while I give certain instructions to counsel for petitioners. Thank you so gently that it's all right. You had already been informed by Attorney Anama that you will be, the continuation of the interpellations for this session will be for you.
Yes, sir.
All right. So I will now be opening the interpellations for those justices, especially who were not able to ask questions during the last session. So please take your seats while I will call on the justices. Who would want to start? Justice Tiham, who had requested that specifically, and then Justice Esmundo.
May I ask Attorney Butuyan some few questions? Attorney Butuyan, in your petition, you specifically mentioned that the anti-drugs campaign of the respondent is unconstitutional because they violated specific provisions of the Constitution and special penal laws. Is that correct?
Your Honor, we are not specifically praying for the declaration of the unconstitutionality of the CMC as clear in our prayers, Your Honor. But we are citing the fact that the CMC violates the Bill of Rights, Your Honor. And we are citing this as reason for the fact that the police are emboldened to do their illegal operations by virtue of this illegal CMC, Your Honor.
So it is your submission that CMC 2016 is not unconstitutional? Is that what you're trying to tell us?
Your Honor, our prayers are only limited to seeking protection for our clients because when we presented the array of options to our clients, Your Honor, they were afraid to frontally confront the government. So they didn't want to specifically pray for the declaration of the illegality and unconstitutionality of the CMC, Your Honor, and they just wanted to be protected, Your Honor.
Okay, so in other words, you're trying to tell us that the circular is not unconstitutional per se.
We did not pray that it be declared, Your Honor, but we are citing the unconstitutionality, Your Honor, in order to bolster our prayer for the protection of our clients, Your Honor.
So what are you trying to assail in this petition? The text of the CMC or the implementation or execution of the said circular?
Both, Your Honor.
Both.
Yes, Your Honor.
So how can you say it's unconstitutional, but at the same time you say you are assailing the implementation? Can you take a look at your petition, paragraph 200? Where is that? Paragraph 200, appearing at page 46 of your petition. No, first let's go to paragraph 196, appearing at page 45. 196.
Paragraph 200, Your Honor.
No, 196, at page 45. You are saying that CMC 16-2016 is unconstitutional. Is that correct?
Paragraph 196, Your Honor. May I read, Your Honor?
Yes, yes.
Moreover, there is no lack for legal or procedural safeguards against abuse by police in anti-drug operations. Pre-operational clearances and coordination with the Philippine Drug Enforcement Agency are required in CMC 16-2016 as well as in the PNP operational manual, Your Honor.
Okay. So in other words, when you cited CMC 16-2016, you are requiring that the respondents to comply with CMC 16-26. And yet in another breath, you're saying CMC 16-2016 is unconstitutional. How is that reconcilable? In fact, you even quoted the provision of the CMC in your petition.
Your Honor, we are citing the fact that the CMC refers to the PNP operations manual, Your Honor.
No.
And under the...
It's very clear in your allegation. Can you read it loudly? Are required in CMC 16-2016. You are relying on CMC 16-2016 in support of your petition, but in another breath, you're saying that issuance is unconstitutional.
Your Honor, in the CMC 16-2016, there is reference to the PNP manual, Your Honor, which requires coordination with the PDEA, Your Honor.
But you're saying here clearly there should have been compliance by respondent in CMC 16-2016,
Yes, Your Honor.
particularly on coordinating instructions.
Yes, Your Honor. We cite that insofar as in the implementation of CMC 2016, that aspect of implementation, Your Honor, the police are not doing the appropriate coordination with the PDEA, Your Honor.
But you're saying that they are not complying with that provision.
Yes, Your
And
Honor.
at the same time, you are saying that it is unconstitutional.
Yes, Your Honor.
So
This
how
is-
can you reconcile something that is unconstitutional in one breath, but in another breath, you're saying there should have been compliance?
Your Honor, the non-coordination with the PDEA is only one of the reasons why we are citing the unconstitutionality of the CMC, Your Honor. In other parts of our petition, Your Honor, we are citing the fact that there is no compliance and there is violation of the Bill of Rights, Your Honor.
Okay, so what you are saying basically in your petition is non-compliance with CMC 2016 that safeguards the right of individuals. Is that correct?
Only with respect to the implementation, Your Honor. That's one aspect, Your Honor.
So
But even on
basically-
its face, Your Honor, the CMC is unconstitutional, Your Honor.
Yeah, but what you're attacking when you read the certain allegations, starting at paragraph 200 and 201 specifically, you are assailing the non-compliance with the procedural requirements set forth. Is that correct?
But yes, Your Honor, but this is only one aspect of our allegations,
Yes,
Your
yes,
Honor.
I'm asking on that particular aspect of your petition.
Yes, Your Honor.
So in other words, you're saying there is a violation of CMC 2016 because there was no compliance by respondent. Is that correct?
With respect to their actions, Your
With
Honor.
respect to this particular
Yes, Your
action.
Honor.
Okay. Do I recall it right that petitioners were not given access to the list of suspected drug, or list of drug suspects? You were not given access to that?
We were not
Given access to the list?
we were not given access, no.
You were
No,
not
Your Honor.
given access?
No, Your Honor.
So how is it possible in your petition specifically citing the affidavit of Sister Nenet to the effect that she was able to verify that the victim was not in the list of suspected drug personalities if you were not given access?
Your Honor, there are instances with respect to particular clients of ours, Your Honor, that the barangay officials mentioned that some of them were in the drug list, Your Honor.
Because in page 30 of your petition, it says there, can you read question 58 and answer 58, please?
Which paragraph, Your Honor?
Page 30 of your petition.
Yes, Your Honor.
So if your clients were denied access to the list, how is it possible that the answer 858, the July drug watch list contains only the names of Crisanto Merced? So how were they able to know that if they were not given access to this list?
Your Honor, I stand corrected. With respect to this particular person, Your Honor, the July drug watch list was given to her by the non-petitioner Amina Merced, Your Honor.
So in other words, there was no denial on the part of respondents to access the list. Is that correct?
Only with respect to one petitioner, Your Honor.
Only one.
Yes, Your Honor.
They were granted access to see the list?
Yes, Your Honor.
Now you are complaining about warrantless searches, correct?
Yes, Your Honor.
That will be illegal under certain circumstances, correct?
Yes, Your Honor.
Now what is the penal sanction for warrantless search?
There is a specific crime for that, Your Honor. But
I tell you, there is
cannot-
none. There is no penal provision penalizing warrantless search. Are you aware of that? Mr. Counsel, there is no penal sanction. There is nothing in the penal code that penalizes warrantless searches.
If I remember correctly, there is a specific crime for the police violation of the constitutional rights of the accused or
You read the case of people, Galvante versus Honorable Casimiro. The Supreme Court was very clear. There is no penal sanction on warrantless searches. So there is a gap in the law. So how can you possibly penalize these public officers when they conduct warrantless searches?
Your Honor, there is a specific provision on the violation of domicile, Your Honor.
What?
Violation of domicile, Your Honor.
Yeah, there is, but with respect to warrantless searches.
But that would be a violation of domicile, Your Honor.
Mr. Counsel, you're asking the court to issue a writ of amparo, is that correct?
Yes, Your Honor.
The purpose is to protect the life, liberty, and security of those who are alive.
Yes, Your Honor.
What about, why are you not pursuing also the accountability of certain respondents named in your petition?
We are, Your Honor.
You are?
Yes,
How?
Your Honor.
What are you doing at this point in time?
Your Honor, it is our submission that it is the obligation of the police, Your Honor, pursuant to the PNP manual, to motu proprio submit all the documents with respect to the killings that they themselves participated in, Your Honor, to the prosecutors, Your Honor, for inquest or preliminary investigation, Your Honor. We humbly submit, Your Honor, that the burden should not be shifted to the families of the victims, Your Honor, because there is an obligation on the part of the policemen, Your Honor, for them to submit the documents to the prosecutors, Your Honor. And besides, Your Honor, with the PNP itself, the DOJ Secretary and the President, Your Honor, saying that there are no extrajudicial killings, encouraging the policemen to go on with these practices, Your Honor. Your Honor, to expect the petitioners, the victims' families, Your Honor, to themselves still file, Your Honor, it's unrealistic, Your Honor. In fact, this is the reason why when we presented to them the range of options, Your Honor, they just wanted to pray for protection, Your Honor.
Yeah, but how do you extract accountability for these police officers which you claim were committing violations of the rights of the victims? If you will not initiate criminal prosecution, because these are the officio offenses that can be prosecuted by anybody, especially the victims' relatives who are still alive.
Your Honor,
Why don't you pursue that avenue? Because the only way, one of the ways to curb these called abuses is to bring them to court. Is that correct?
Yes, Your Honor, but how can we even initiate these actions when the police would not even give the documents, Your Honor, that constitutes their investigation? In many instances, there are even no SOCO reports, Your Honor. And besides, Your Honor, our petitions are dual in nature, where after the preventive purpose of amparo, which is to secure protection for our clients, we are also after the curative purpose of amparo, which is to exact accountability by requiring the policemen to submit all the documents relative to the killings that happened in their hands, Your Honor, to the prosecutors, Your Honor.
You said exact accountability, but the best way to exact accountability to these perpetrators is to file charges against them, isn't it?
We don't have the documents, Your Honor. The documents are with the police, Your Honor.
But I look at your judicial affidavits attached to your petition, the voluminous, and I must commend the efforts to document this number of killings. Don't you think that that will be sufficient, at least for the initial stage of the criminal prosecution?
We will do that after the Honorable Court, Your Honor, if we're lucky, would direct the police to give us copies of the documents, because among our prayers, Your Honor, in this petition is that the respondents give the petitioners copies of all the investigation reports and the medical legal and the SOCO reports, Your Honor.
Because basically, the incidents you allege in your petition involves killings, right? Which can be either murder or homicide, but the statements in your judicial affidavits accompanying your petition. Don't you think that is sufficient to initiate a criminal complaint before the prosecutor's office or the ombudsman, as the case may be?
As soon as we have the
Because you
documents,
have the details of persons involved, the time and the incident, who got killed, don't you think that is sufficient?
Your Honor, out of the 33 killings that we documented, only two incidents have police documents. The rest, they don't have police
Yeah,
documents, Your Honor.
but there are narrations in the affidavits, especially that of Sister Nenet, that details and give specifications on the specific incidents. Who got killed, who were responsible officers who conducted the raid. So this would be at least be sufficient to initiate a criminal complaint. Is that not correct?
Not yet, Your Honor, until we
Not
get
yet.
the documents, Your Honor. Yes, Your Honor.
Now, if you are saying that the respondents are not providing you documents, don't you think that by filing a complaint with the prosecutor's office, making them respondents for purposes of preliminary investigation, that will compel them to the production of these documents, instead of us telling these executive officials to do the following acts as prayed for in your relief?
Your Honor, considering the many documents and there seems to be a systematic action on the part of the policemen to withhold all these documents, Your Honor. That's why we are beseeching the Honorable Court to direct the police, Your Honor, to release all these documents so that we can file the appropriate criminal actions against them, Your Honor.
But those are things that are, would be proper at the trial proper, but at least for purposes of preliminary proceedings, don't you think the judicial affidavits is insufficient?
We think that we still need the documents, Your Honor.
Thank you, Attorney Butuyan.
Thank you.
Justice Diham.
Good afternoon, Council.
No, please, Your Honor.
May I address this question to Dean Jokno? Good afternoon, Dean Jokno.
Good afternoon, Your Honor.
Do the petitioners know the identity of the persons who allegedly committed the extra-legal killings?
It varies, if Your Honor, please. In the case of Jefferson Soriano, he cannot identify the shooter, the
Yes.
assailant.
But have cases been filed, whether civil, criminal, or administrative, against the perpetrators, or if the perpetrators are not identified? Has this incident been officially reported to the police?
As far as I know, in the case of Jefferson Soriano, there is no pending criminal, administrative, or even civil complaint in his case.
Would you agree that reporting this to the police and having this investigated is a more realistic, productive mode? Or is it the impression of petitioners in both cases that there is reluctance, refusal on the part of the police to take action on these cases?
In the case of Soriano, Your Honor, there is a lot of fear on his part, considering that he was shot just days after he had been taken in to the police, tortured inside the police precinct, because apparently they were looking for somebody else and they wanted him to tell the police the whereabouts of this person. So he would, I think, naturally be afraid to go back to them, since it would seem to him that they would have some responsibility for the attack on his person.
Now, I address this to both counsel for the petitioners. The subject PNP memorandum circular requires the submission of reports on the anti-illegal drug operations. Have you asked for copies of these reports from the PNP? Or if you did, was the request refused or declined?
On behalf of the Free Legal Assistance Group, we have pending requests under the Freedom of Information Executive Order for these reports. We have made these requests months ago, if Your Honor, please. We have received some replies that they are in the process of being compiled. We have not received any substantive responses to our request, Your Honor.
In the petitions, petitioners question the lists being submitted by the barangay for not being published and for being, the list of the PNP for not being published and for being based primarily on names supplied by barangay officials. Is there something illegal, irregular about that kind of procedure?
Yes, Your Honor. After the hearing last time, I recalled the case of Robinson versus California. This is a U.S. Supreme Court decision where the state of California made it a crime for a person to be a drug addict. And the U.S. Supreme Court vacated his conviction because they said you cannot penalize a status. You can penalize only criminal acts. We submit, Your Honor, that those lists include persons who are perceived by the community as drug addicts, that those lists include names of those such persons, and in effect, it makes them targets of police action when the status of being a drug addict is really, by consensus of many countries, an illness rather than a crime. It is a crime under our laws to possess, to use, to sell drugs, but to be a drug addict per se is not criminalized by RA 9165 or any other law that I know.
Is this prevalent among the PNP that they do not validate, they do not verify, they do not authenticate this so-called list given by barangay officials? Is this common practice in most of the barangays?
The circular, Your Honor, simply states that the compilation of lists should be validated, but this is internal. This is, as far as we know, done only within the PNP and no, without any transparency on their part. So we have no knowledge of how that validation is done or even if it is actually done on the ground.
You want the circular, the petitioners want the circular struck down as unconstitutional because the PNP memorandum circular speaks of neutralization, negation of illegal drug personalities. And according to petitioners, these terms could only mean killing them based on what was actually implemented or done by the police. Also, pronouncements from some government officials and even the president. But the circular, however, explicitly requires that the House visits shall not violate the rights of the subject and that all anti-illegal drug operations shall conform to the Bill of Rights under the Constitution, allied laws, the principles of international law and public policy, and that there shall be due observance of human rights. So, on its face, this circular, we do not agree. This would negate the impression that neutralization and negation, as used in the circular, are intended to mean to kill drug personalities.
If Your Honor, please, while the circular does mention that they should respect the rights of the persons, if you look at the provision, if Your Honor, please, on the Tokhang visits, it states that any person who denies or refuses the visit shall be subjected to immediate case build-up and negation. In other words, Your Honor, there is a penalty attached to one's exercise of their right. It is every person's right to refuse entry or inspection by a police into their home if there is no search warrant. In this particular case, refusal carries with it a form of penalty. We submit, Your Honor, that even if there are provisions that require adherence to the Constitution, those other provisions, such as that of negating them, or in other provisions neutralizing them, are contradictory to those provisions which demand respect to human rights.
At the end of the day, aside from asking for protection from the court by way of a writ of amparo, you also want this court to declare that there is extrajudicial killing. But this would mean taking into account factual the facts of the case, certain details, but you know very well that we have dismissed a lot of cases on the basis that this court is not a trier of facts. We may be called the court of last resort, but we are not a court of all resorts. So how would you reconcile that? How can we make a declaration that there is extrajudicial killing on the surface, solely on the basis of a circular, solely on the basis of the certain incidents in the implementation of this circular, without gathering facts? Is
If I
this
may.
something that should have been filed before the lower courts?
If I may clarify, if Your Honor, please, we are not asking the court to declare the existence of extrajudicial killings per se, especially without the reception of any evidence. We understand the nature of the Supreme Court. What we have filed is a petition for prohibition to enjoin the implementation of Command Memorandum Circular 16. One of our grounds for that is that the circular can easily be construed by the police officers on the ground to authorize shortcuts that would be infringing on basic fundamental rights of the people, and which have in fact infringed on the rights of our petitioners. We know, Your Honor, that the procedure in a writ of amparo is after the writ is issued. The court generally, if it takes cognizance of the case, will delegate reception of evidence to the Court of Appeals or a lower court, as it has done in other cases. We are prepared, Your Honor, please, to present our evidence before the lower court.
Based on the information you gather from the barangays with respect to the implementation of this Operation Tokang, is it your conclusion that predominantly they're not happy with the implementation of Operation Tokang? Or are there some barangays who are satisfied or contented with the implementation of that?
I'm
police
afraid I'm
operation?
in no position to answer that, Your Honor. I have not really gone to many barangays. People have come to me who have been victims of killings, and I can gather impressions from them, but not from the general communities or the barangays, Your Honor. I'm sorry.
All right. Thank you very much, Lim. I'm done.
Justice Velasco.
We call Attorney Butuyan to the rostrum. Attorney Butuyan, you are one of the counsels for Danyo, petitioners Danyo et al., right?
Yes, Your Honor.
Okay, and the rule on writ of amparo states that, or requires that you should state the names and the personal circumstances of the person responsible for the act or omission or threat. Is that correct?
Yes, Your Honor.
You mentioned several persons that were killed in your petition. How many did you mention that were killed as a result of the implementation of Project Tokang?
35 deaths, Your Honor.
35 deaths. Okay, and did you specify in your petition what are the names of the persons responsible for the around 35 deaths?
As far as the petitioners can remember, Your Honor, we specified, Your Honor, but there were instances, Your Honor, where the names could not be obtained by some of the petitioners, Your Honor.
Okay, so the witnesses to the killings were not able to know the names of the persons who perpetrated the killings. Is that what you're saying?
Some of them, Your Honor, because they were in civilian clothes, they were armed men, but in most of these incidents, the police would guard the perimeter, Your Honor.
Okay, there are several respondents in your petition, who among the respondents here are the persons allegedly responsible for the 35 deaths?
We identified the... May I just get our petition, Your
Please.
Honor? Your Honor, starting in paragraph 57, Your Honor, we identified the police officers, Your Honor, who are identified in the affidavits of some of the petitioners, Your Honor.
Okay, so they were made respondents here around up to letter O, okay? And you want the court to issue a writ of amparo to require them to submit a return as to their probable involvement in the killings. Is that correct?
Yes, Your Honor, and we also pray, Your Honor, that in the meantime, Your Honor, they be reassigned to outside of the San Andres Bukid area, Your Honor.
Okay, so aside from this oral argument, you are asking of this court to issue a writ of amparo to these persons listed under that particular paragraph to state in the return whatever defenses they have to the alleged killing, correct?
Yes, Your Honor.
Okay, and since the court is not a trier of facts, would you be amenable to a referral to the Court of Appeals just to find out what will be the contents of the returns of these alleged perpetrators of the killing subject of your petition?
Perhaps with respect to the curative nature of amparo, Your Honor, but with respect to the preventive nature of amparo, Your Honor, we are praying, Your Honor, that the policemen be reassigned outside in the meantime, Your Honor, of San Andres Bukid, Your Honor, because of the threat to the security of the petitioners. In fact, we have incidents, Your Honor, that some of our petitioners are experiencing forms of harassment, Your Honor.
Okay, so you want a provisional relief aside from the other preliminary reliefs that you have stated in your petition, that
Yes,
they
Your
be reassigned outside of the district. Is that correct?
Yes, Your Honor.
Okay, and in case the court finds merit in your prayer for such relief, then we may have to go to certain factual matters here that are, of course, necessary in a petition for a writ of amparo. Is that correct?
Your Honor, we have so many undisputed facts in this particular petition, Your Honor. In fact, in the return that was filed by the Solicitor General, Your Honor, they did not dispute the fact of death of almost all of our petitioners, Your Honor. And in fact, Your Honor, we have cited news reports, Your Honor, where the police were quoted admitting that they were the ones who, in whose hands the killings happened, Your Honor.
Okay, the fact of deaths are admitted, but you're aware that under the rule, the respondents must be given the opportunity to also submit a return of the writ. Is that correct?
Yes, Your Honor.
And so we have not gone to that stage yet, and considering that your petition is solely confined to the application of the rule on the writ of amparo, there may be a need for a summary hearing, correct?
Yes, Your Honor. But with respect to the preventive nature of our petition, Your Honor, we humbly submit, Your Honor, that there are enough undisputed facts that would warrant a summary decision by this honorable court, Your Honor.
Yes, the court, I believe, will be in a position to grant your prayer for this provisional reliefs. And then we, in my view, it may have to be referred to the Court of Appeals to conduct the summary hearing into the allegations in your petition, especially the alleged participation of some of the respondents. Do you agree?
Your Honor, with respect to the criminal liability of the police, Your Honor, we submit, Your Honor, that they should be tackled by either the Department of Justice or the Ombudsman, Your Honor. And among our prayers, Your Honor, is that the respondents be directed to submit all the documents pertaining to the investigation, Your Honor, of the deaths, Your Honor, to the prosecutors or the Ombudsman as part of our curative prayer, Your Honor, under the rito comparo, Your Honor.
As I said, the court may rule on these prayers for provisional remedies at this time, even before referral to the Court of Appeals, should the court decide to refer it to the Court of Appeals for the summary hearing. But then you were able to point to certain members of the police force as the perpetrators of the killings. So are you telling the court that you have witnesses who executed the judicial affidavits that identify these persons as the perpetrators of these crimes?
Yes, Your Honor.
You have, and
Yes,
the judicial affidavits of these witnesses are attached to the petition, correct?
Yes, Your Honor.
And with these affidavits, you can already proceed to file the criminal complaints against these police officers. Why did you not file the criminal complaint with the City Prosecutor of Manila?
Your Honor, we humbly submit, Your Honor, that the burden should not be shifted to the petitioners, to the victims' families, Your Honor, because it is very clear under police manuals, Your Honor, that it is the obligation of the policeman, Your Honor, in cases where deaths happen in their hands, Your Honor, that they motu proprio, Your Honor, are required to submit all the documents, Your Honor. In fact, Your Honor, there were efforts by by the lead petitioner in this case to dialogue with the police and seek information and documents and the investigation reports, Your Honor. But the letter which was submitted on May 11, Your Honor, it was not responded to by the police, Your Honor.
No, but if there are eyewitnesses to the killings, even a sole witness, a lone witness, can serve as a basis for the filing of a criminal complaint against the erring police officer. And you said you have eyewitnesses to the killings. And with these sworn statements of your eyewitnesses, that can serve as a basis for the filing of the criminal complaints before the city prosecutor. Is that correct?
It will be a matter of timing, Your Honor. We want first protection for our clients, Your Honor, because they're very afraid even to just obtain information from the police. Much more, Your Honor, filing criminal cases against the police. That's why we came to this honorable court, Your Honor, for protection before we can file the appropriate criminal cases and also obtain the documents that we need in the filing of criminal cases later on, Your Honor.
Well, I'm not questioning how you will strategize in protecting your clients, but I just want to know why the criminal complaint was not filed when you already have an eyewitness to the killing. And although, of course, you try to justify it by saying that you still need additional documents. But if you have an eyewitness to the killing, and that is enough, I believe, to warrant the filing of an information before a court. And that is precisely the reason why we are running after the erring policeman, is to bring him to the bar of justice. And once he's convicted, definitely it will set as an example to the other policemen not to commit the same dastardly act. Isn't that correct?
Your Honor, at this point and in the current atmosphere, Your Honor, the petitioners are afraid to file criminal charges against the police, Your Honor.
Oh, so they're afraid. But what happens after you get all these documents? Are you not, are you not intending to still file the criminal complaint against the alleged perpetrator?
We will have to talk to the petitioners,
You
Your
will
Honor,
have
if at
to
what time
do
they
it
want.
later. That's what you're saying.
Yes, Your Honor.
Okay. Now, what is really the relief that you are asking from the court as part of the privilege of the writ of amparo that may be granted by the court? What specific reliefs? Because you mentioned the provisional reliefs, no? And I said the court, if warranted by the petition and also the attachments to your petition, may grant it, no? But at the end of the day, after the exchange of pleadings, after this oral argument is done, and I believe after a summary hearing before the Court of Appeals, what are you really asking from the court? What reliefs?
Your Honor, among others, we have multiple prayers for relief, Your Honor. Among others, Your Honor, we are seeking the transfer of the police of Station 6, Manila Police Station 6, Your Honor, and that they be prevented from coming near within a 1 kilometer radius from the residence of the petitioners. Your Honor, we are praying that the police, Your Honor, submit the investigation reports, the SOCO reports, the inventory of firearms, Your Honor, to the prosecutor for preliminary investigation purposes, Your Honor.
Okay.
We are
It seems
praying.
that some of the reliefs you're asking are means to get or obtain evidence, like the modes of discovery, like production and inspection, correct? Production of documents, more particularly, correct?
Among others, Your Honor.
Okay, but at the end of the day, you want these reliefs to, like, the transfer that of the policemen. So you're asking us to order them not to be reassigned and back to the District 6. Is that what you're saying?
Among others,
That
yes.
there will be a certain area where they cannot go in and possibly perpetrate again the acts that you're complaining of, correct?
Yes, Your Honor.
That's all, Madam Chief Justice.
Is there any other justice who would like to ask anything from petitioners? Petitioners? Okay, thank you very much, Attorney Butuyan. May we request Sergeant Calida, please, to stand up. And thank you very much, Sergeant. The court really appreciates your full cooperation. We are impressed by the roster of resource persons that are here this afternoon.
My pleasure, Your Honor.
Thank you. Sergeant, you have 30 minutes for your presentation.
Yes, Your Honor. Good afternoon, Your Honors, and may it please the Honorable Court. In an attempt to question before this Honorable Court the legitimacy of the government's anti-drug campaign, the petitioners seek a hodgepodge of relief that should not be granted. The extraordinary writ of amparo is intended to safeguard every person's right to life, liberty, and security. It cannot be utilized, as the petitioners are doing, to harass, vex, or hinder public authorities in the legitimate exercise of their duties. The writ of prohibition, on the other hand, can only be sought by one who has legal standing and where there is something to prohibit. These two conditions are clearly not present in this case. It is therefore not difficult to see that the present petitions are disingenuous moves to destabilize the Duterte administration and sow anarchy. For one thing, the Almora petition prays that the respondents or any of their agents, representatives, or assigns be prohibited from implementing or enforcing any instructions, commands, or utterances of President Duterte to the PNP and or the ILG in relation to the war on drugs and anti-illegal drug campaign, quote unquote. For another, the Danyo petition asks this honorable court to declare police-free zones. Plainly, the petitioners intend to, number one, drive a wedge between the President on the one hand and the PNP and DILG on the other, inciting disobedience to the Chief Executive and depriving him of his powers and prerogatives. Number two, emasculate the government's police powers by rendering inutile the PNP's sworn mandate to enforce the law and maintain peace and order. The court should not let these happen because they will have long-term catastrophic effects on the nation's stability and security. That said, I will now discuss at length why the consolidated petitions are procedurally infirm and why the respondents' campaign against illegal drugs has been consistent with the Constitution and both domestic and international law. Let me proceed to the procedural issues. First, the class suit in the Danyo petition is improper. The petitioners in Danyo claim a common or general interest by, quote, collectively filing the petition as a class suit for and in behalf of all the residents of the 28 barangays of the San Andres Bukid community, unquote. The petitioners, however, cannot possibly have the same interest in the life, liberty, and security of different persons who suffered from the alleged wrongdoings of the respondents. There is no class action to speak of, since there exists no common and general interest in the separate experiences of the alleged victims. That the petition is a class action is belied by the resolutions of 67 barangay councils in San Andres Bukid, expressing their support for the fight against illegal drugs. In addition, all 26 barangay captains referred to by the petitioners repudiated in a sworn statement dated November 7, 2017, the allegation regarding the peace and order situation in San Andres Bukid. More than 1,000 residents of San Andres Bukid, as well as tricycle operators and drivers association and other local organizations in the area, have also executed affidavits agreeing and supporting the police anti-drug program. Second, the petitioners in Danyo have no locus standi. The rule on the writ of amparo categorically establishes a successive and exclusive list of people or groups of people who may file a petition to obtain the writ. The aggrieved party should primarily file the petition. If the aggrieved party cannot do so, the rule allows any immediate family member of the aggrieved party, spouse, children, parents, to file the suit. Thereafter, collateral relatives within the fourth civil degree of consanguinity or affinity may file it. A concerned citizen or organization can file the petition only when the aggrieved party and his immediate and collateral relatives are unable to do so. Third, the Honorable Court should not take cognizance of the petitions. The respondents respectfully submit that the Honorable Court should not take cognizance of the instant petitions because the relief being sought, and I quote, to restrain the Philippine National Police from implementing CMC number 16-2016 and to stop them from carrying out instructions or utterances of President Duterte, unquote, is tantamount to an undue interference with the operations of the executive branch of government. It violates the doctrine of separation of powers enunciated in Bellica versus Secretary Ochoa, where the Honorable Court declared that there is a violation of the Constitution when one branch of government impermissibly interferes with the performance of another. Granting the consolidated petitions will result in a constitutional crisis. Fourth, the petition should be dismissed for lack of proper verification and certification against forum shopping. In Almora, the petitioners signed the verification and certification against forum shopping on September 8, 2017, September 12, 2017, and October 3, 2017, respectively, weeks before the petition was prepared on October 10, 2017. Likewise, in Danio, the petitioners signed the verification and certification against forum shopping on October 16, 2017, or 2 days before the petition was made on October 18, 2017. They certified that they read the petition and affirmed that its allegations and attachments are true and correct of their own personal knowledge or based on authentic records. How can they now truthfully say this when the petitions have not yet been finished or prepared? Such perjurious acts warrant the outright dismissal of both petitions. There is no justification to relax the rules and excuse the petitioner's non-compliance with these rules. Fifth, the petition involved misjoinder of causes of action. As the cases arose from separate incidents, the joinder involving Ryan Dave Almora, Rex Apari, and Jefferson Soriano in Almora petition, and of Conrado Beronia and the 34 other alleged aggrieved parties in Danio is improper. Trial and reception of evidence will have to be completed for each circumstance before a resolution of the entire case can be had. Thus, the purposes of a joinder of causes of action, avoiding multiplicity of suits, and expediting the proceedings will not be achieved, as there cannot be a single unified resolution of the merits in all these incidents. The petitioners also questioned the constitutionality of CMC 16-2016, but none of the incidents mentioned in the petitions involved Project Tokhang. Sixth, the petitioners failed to show that the respondents violated their right to life, liberty, or security since they did not comply with Section 5 of the Rule on Amparo and relied on hearsay evidence. Section 5 of the Rule on Amparo provides that a petition for the issuance must state the right to life, liberty, and security of the aggrieved party violated or threatened with violation by an unlawful act or omission of the respondent, and how such threat or violation is committed with the attendant circumstances detailed in supporting affidavits. The petitioners dismally failed to satisfy this requirement. Contrary to the sworn statements in the petitioners' verification and certification, their claims of violations or threats of violation to their life, to the right to life, liberty, and security, as contained in the petitions, are based merely on hearsay and speculation. In particular, Sister Danio and the 17 lay mission partners based their allegations entirely on news articles and information they gathered during the visits to the wakes of the alleged victims. let me turn to the substantive issues, Your Honors. Assuming arguendo that there is compliance with all the procedural requirements, the petition should nonetheless be dismissed for lack of merit for the reasons I will now state. PNP CMC number 16-2016 and DILG MC number 2017-112 are constitutional and were issued by the PNP chief and the DILG secretary under their respective authorities. The PNP chief issued CMC number 16-2016 in the exercise of his authority under Section 26 of RA 6975, which is the Department of Interior Local Government Act of 1990. The law grants him, referring to the PNP chief, the power to direct and control tactical as well as strategic movements, deployment, placement, utilization of the PNP, unquote. The DILG secretary, on the other hand, issued DILG Memorandum Circular number 2017-112 in the exercise of his authority under the Administrative Code of 1987, which states that the Secretary can promulgate rules, regulations, and issuances necessary to carry out the department objectives. CMC 16-2016 and DILG MC number 2017-112 cannot be construed as directing the performance of an unlawful act. The petitioners assert that the safeguards under Section 8, paragraphs E and F of the CMC number 16-2016 constitute mere lip service. Furthermore, they allege that the subject PNP Memorandum Circular is unconstitutional because of its use of the terms, quote, negated, unquote, and neutralized, quote, unquote. They construe these terms as synonymous to, quote, killing, unquote, and assume that PNP CMC number 16-2016 directs the killing of drug personalities. The petitioners have a skewed interpretation of these words. Neutralization was defined under CMC number 11-27 as referring to the arrest of a surrender of an illegal drug personality. Likewise, it refers to the death of a drug personality during legitimate drug operations. Viewed in their purely legal contexts, these terms should not be construed as synonymous to extrajudicial killing, but as a comprehensive term that includes to subdue, incapacitate, arrest, and in the most extreme case, when the life of the police officer is endangered, to kill. This is not the first time that these words found their way into the police operational manual. The words neutralize and negate had already been used in PNP Operational Procedure of 2010, Manual on Anti-Illegal Drugs Operations of 2010, Revised PNP Operational Manual of 2013, and Revised PNP Manual on Anti-Illegal Drugs of 2014. In insisting that CMC number 16-2016 is constitutionally infirm for allegedly advocating extrajudicial killing, the petitioners confuse the validity of the circular with the abuses allegedly committed by law enforcers in the implementation of the anti-drug war program. The court in David versus Macapagal Arroyo held that, quote, courts are not at liberty to declare statutes invalid, although they may be abused and may afford an opportunity for abuse in the manner of application. The validity of a statute or ordinance is to be determined from its general purpose and its efficiency to accomplish the end desired, not from its effects in a particular case, unquote. As in David, this august tribunal will again ask itself the same query. May this court adjudge a law or ordinance unconstitutional on the ground that its implementer committed illegal acts? And the Supreme Court said no. The answer is no. The criterion by which validity of the statute or ordinance is to be measured is the essential basis for the exercise of power, and not a mere incidental result arising from its exertion. This is logical. Just imagine the absurdity of situations when laws may be declared unconstitutional just because the officers implementing them have acted arbitrarily. If this were so, judging from the blunders committed by policemen in cases passed upon by the court, majority of the provisions of the revised penal code would have been declared unconstitutional a long time ago, unquote. The acts authorized or conducted under the authority of PNP CMC number 16-2016 and DILG MC 2017-112 do not violate any constitutional, statutory, or administrative provisions. Project Tokhang under CMC number 16-2016 has 5 stages, and I will explain this at length during the interpellation. First, collection and validation of information stage, where information on suspected drug users and pushers is acquired and verified through a 5-tier validation process. Number 2, the coordination stage with LGUs, PDEA, DDB, and the Anti-Drug Abuse Councils, the Philippine Information Agency, and NGOs. Number 3, the house-to-house visitation stage. This is the highlight of Project Tokhang, whereby a team is first organized. The designated team leader is mandated to ensure the presence of either the provincial, city, municipal, or barangay drug abuse council, as the case may be, and the barangay tanods to assist them and to serve as witnesses in the conduct of the house-to-house visitations. CMC number 16-2016 further requires that this visitation be done in a manner that shall not violate the rights of the subject. Any person who is willing to undergo voluntary rehabilitation shall be processed accordingly. Number 4, the processing and documentation stage, where the voluntary surrender form is accomplished and the person of interest is interviewed. Number 5, the monitoring and evaluation stage, where the police action is taken in case of continued drug activities. Project Tokhang, by its nature, is different from buy-bust operation. The revised PNP Manual on Anti-Illegal Drug Operations and Investigations defines buy-bust operation as an entrapment technique employed by peace officers as an effective way of apprehending a criminal in the act of committing an offense. On the other hand, Project Tokhang is a means of effectively accelerating the drive against illegal drugs in affected barangays after a thorough validation process. It is only after the validation process has been completed that house-to-house visitations are conducted to persuade suspected illegal drug personalities to stop their activities and turn a new leaf in life. In Project Tokhang, the subject cannot be considered a suspect, while in a buy-bust operation, the subject has already been identified as a drug pusher. In Project Tokhang, the person of interest is not under arrest or put in custody. The purpose of the house-to-house visitation is not to arrest, but to persuade the person of interest to stop his illegal activities. On the contrary, in a buy-bust operation, the suspect is identified drug pusher from whom the law enforcers aims to entrap and apprehend. Because of the deprivation of liberty, a buy-bust operation requires observance of the rights of persons under custodial investigation and of persons arrested. In Project Tokhang, such rights cannot be invoked. Nonetheless, respondents advance that there is no violation of the Constitution and relevant statutes. 1. There is no violation of Section 11, Article 2 of the Constitution on the state policies of human rights. In fact, CMC number 16-2016 gives due consideration to human rights. Section 8E of the CMC requires all operations to conform with the provisions of RA number 9165 and the rules of court, and to strictly observe the rights of the accused in the Bill of Rights, other allied laws, rules, and regulations, as well as internationally accepted principles of international laws, public policy, and with due observance of human rights. Section 8F further mandates all concerned personnel to strictly observe the rights of persons arrested, detained, or under custodial investigation. 2, there is no violation of Section 1, Article 3 of the Constitution on the right to life, liberty, and property. What is proscribed is the taking of life and deprivation of liberty without due process of law. The taking of life and deprivation of liberty adverted to by the petitioners were the result of legitimate police operations and not through Operation Tokhang. 3, there is no violation of Section 2, Article 3 on the right against unreasonable searches and seizures. As a general rule, a search to be valid must be accompanied by a search warrant. A house-to-house visitation cannot, however, be construed as a search. The purpose of the house-to-house visitation is simply to persuade the drug personalities to change their ways. 4, no violation of the rights of persons under investigation or persons arrested under Section 12, Article 3 of the Constitution. The rights of persons under custodial investigation can only be invoked when the person is taken into custody. 5, there is no violation of the rights of the accused under Section 14, Article 3 of the Constitution. The applicability of Section 14 presupposes an ongoing criminal prosecution. House-to-house visitation is merely an informal gathering operation by the police. Therefore, the rights under Section 14 cannot be invoked by the petitioners. There is no violation of the right of the accused against self-incrimination in Section 17, Article 3. What is prohibited is the use of physical or moral compulsion to extort a confession from the witness or to otherwise elicit evidence that would not exist were it not for the force used on the witness. These rights can only be invoked in criminal cases. 6, CMC number 16-2016 and MC number 2017-112 likewise do not violate RA number 7438, which provides for the rights of persons who are arrested, detained, or placed under custodial investigation. Project Tokhang does not involve the arrest and detention of a suspect. It is not also a part of custodial investigation. The protection afforded by RA number 7438 cannot thus be invoked in this case. 7, People versus Doria and the stop and frisk doctrine are inapplicable since CMC number 16-2016 applies to house-to-house visitations, encouraging voluntary surrender of drug dependents. On the other hand, MC number 2017-112 merely gives citizens an opportunity to report wrongdoing. These issuances do not govern by-bus operations or stop and frisk searches. 8, there is no violation of Article 125 of the Revised Penal Code on inquest and the delivery of detained persons to the proper judicial authorities. The PNP complied with Article 125 of the Revised Penal Code. All apprehended drug personalities were submitted for inquest proceedings within the period prescribed and thence criminally prosecuted. Besides, CMC number 16-2016 and MC number 2017-112 do not deal with the handling of arrested drug personalities for inquest. 9, there is no violation of Chapter 3, Rule 15.4 of the revised PNP operational procedures, which requires submission for inquest of incidents where the suspect dies. The provision must be read together with Section 16 of DOJ Circular Number 61, dated September 21, 1993. Section 16 of said circular, inter alia, requires the presence of an inquest prosecutor only when, quote, a dead body is found and there is reason to believe that the death resulted from foul play or from unlawful acts or omissions of other persons, unquote. Your Honors, the death referred to in the petitions resulted from legitimate police operations. The presence of the inquest prosecutors at the place of operation was unnecessary. Rule 15.4 of the revised PNP operational procedures is therefore effectively circumscribed by the provisions of Section 16 of the DOJ Circular Number 61. The acts authorized or conducted under authority of CMC number 16-2016 as well as MC number 2017-112 do not violate the Philippines' international legal obligations under the International Covenant on Civil and Political Rights and the Minnesota Protocol. The Philippine government has faithfully complied with the ICCPR, a key human rights treaty providing a range of protections for civil and political rights. CMC number 16-2016 being operational guidelines covering house-to-house visitations does not violate the rights of persons of interest. The visits are based on verified information. The police respect the right of a person of interest to refuse visitation. In turn, the Masa Masid under MC number 2017-112 does not involve pointing furtive fingers toward anyone who may be accused of a crime. It provides for a vetting process requiring a technical working group to validate submitted reports and refer them to the concerned government agencies if needed. Thus, both CMC number 16-2016 and MC number 2017-112 are compliant with the ICCPR. The unfortunate deaths mentioned in the present petitions cannot be classified as potentially unlawful under the Minnesota Protocol. There were no findings that the killings were state-sponsored killings and that they were committed with the state's acquiescence. In particular, 27 of the 35 deaths in Daño and the 2 deaths in Almora were the result of legitimate police operations. The remaining 8 incidents in Daño involved 4 homicides currently under investigation and 4 others that have not been reported. The assailant in the last incident in Almora involving Jefferson Soriano remains unidentified. Nevertheless, the PNP is investigating these deaths, demonstrating its commitment to the Minnesota Protocol in good faith. There is no basis for the Honorable Court to grant petitioners interim relief. The petitioners failed to show any clear legal right for the injunctive relief to issue, just as they have not shown any compelling evidence that their life, liberty, and security are in imminent danger to warrant the writs of prohibition and amparo. These remedies they have resorted to can be considered as a broad plea to strike down prevailing law enforcement practices on dubious constitutional grounds rather than on distinct and personal threats to their lives and safety. In Losada Jr. versus President Arroyo, the court ruled that interim relief in amparo proceedings can only be granted if there is clear showing of an imminent and continuing threat on the life and liberty of the petitioner. The petitioners in Almora did not discuss the nature of threats they were being subjected to by the respondents. The petitioners in Daño, on the other hand, failed to show a credible nexus between the killings in San Andres Bukid and the present threat to their safety. There is thus no justification for the issuance of a temporary protection order. Ironically, it is in the Daño prayer for a 1-kilometer radius where the respondent law enforcers would not be allowed to enter, that would produce the threats to their own lives and well-being. It would effectively create police-free zones, a safe haven for criminals within the community. Police authorities would be unable to perform their mandate to enforce the law and order. On the screen now is an image showing the area of responsibility of the Manila Police District Station 6. The yellow portion is San Andres Bukid. The red is Dagonoy, and the blue covers Punta. The numbers on the screen refers to areas where the alleged incidents in these petitions happened. The zones encircled by the red lines indicate 1 kilometer radius where respondents would not be allowed to operate. In this case, or any other court would grant petitioners prayer for police-free zones. Clearly, the respondent would thus be limited to operating within less than one half of Punta, and would not be able to enter the entire San Andres Bukid, and would not be able to enter and Dagunoy rather. Affected establishments in these areas include 3 banks, 8 schools, 4 gasoline stations, and 8 pawn shops. This number do not include small businesses and residential areas which respondents would not be able to patrol and protect. In view of the preceding arguments, the petitioner's prayer for the issuance of production and inspection orders must also be denied. As the court held in Balao versus Macapagal Arroyo, prayers for production and inspection orders predicated on bare allegations cannot be granted. The court added that it cannot sanction fishing expeditions by the precipitate issuance of production orders. Before I conclude, let me point out that under Project Tokhang, which commenced in July 2016, 8,247,489 houses were visited. 1,262,188 drug personalities voluntarily surrendered. This is unprecedented. The government has built rehabilitation centers for those in need of rehabs. The success of the Project Tokhang is reflected in the overwhelming approval of the people for the government's anti-drug campaign. In a recent survey by Pulse Asia, covering the period of September 24 to 30, 2017, shows that 88% of Filipinos support the war against illegal drugs. In the NCR, where the petitioners reside, the anti-drug campaign garnered an approval rating of 84%. The resolution by the Honorable Court of the legality of the drug war will define the future of this nation. The court cannot and should not be swayed by meretricious arguments of the petitioners. Certainly, there is no lawful basis for the court to prohibit the respondents from implementing and enforcing the orders of the President. There is also no legal authority for the same court to order police-free zones. What the petitioners therefore want is a country mired in drug addiction, where lawlessness and anarchy hold sway. In closing, let me quote the prophetic words of this honorable court in the 1988 case of People versus Romeo Policarpio, and I quote, "Drug addiction is one of the most pernicious evils that has ever crept in our society. More often than not, it is the young who constitute the greater majority of the citizenry who are the victims. It is of common knowledge that drug addicts become useless if they do not become dangerous members of the society. In some instances, they turn out to be among the living dead. This is the reason why the courts and the law enforcement agencies should continue in their relentless campaign, not merely to minimize, but to totally eradicate the evil before it's too late. The peddlers of drugs are actually agents of destruction. They deserve no less than the maximum penalty. The road that leads to a drug-free Philippines, Your Honors, is long and arduous. The task is formidable, but the government's resolve to win this war against drug addiction will neither wane nor weaken. It will take all of us to protect our country from being populated by living dead addicts. And the time to act is now. Thank you, Your Honors.
Thank you, Soljan. Please stay on the rostrum. Upon request, and for the more appropriate justice having yielded, I'll now call on Justice Leonen.
Good afternoon. So, the Honorable Solicitor General, good afternoon.
Yes, Your Honor.
Pleasure to be engaged with you again in this forum. Good afternoon. You are the tribune of the people, is that not correct? You are the tribune of the people, is that not correct? Apart
Yes,
from
Your
your other appellations,
That is one of my functions, Your Honor.
yes. And oftentimes you are referred to as the 16th Justice of the Supreme Court, is that not correct?
Well, some say that, Your Honor.
Yes. And therefore, your duty is not only to protect the administration, but likewise to protect the rights of the people. Is that not correct?
Yes, Your Honor, especially the youth,
The youth, yes.
the youth of the land, Your Honor.
Yes,
who are the victims of these illegal drugs, Your Honor.
Yes, but I hope you do not forget the senior citizens, many of whom are sitting with me.
Yes, Your Honor,
Yes,
and I'm
okay.
also standing here.
Yes.
Yes, Your Honor.
Well, I didn't know. I thought you were part of the youth. My colleagues are objecting, so I will take note of their objections. But because you're a tribune of the people, you are aware that in a democracy there can be there can be criticism of us public officials. Is that not
Yes,
correct?
yes, Your Honor.
Yes. In
We
fact,
should not be onion-skinned, Your Honor.
yes, in U.S. versus Bustos, penned by the Venerable Justice Malcolm, and in the cases of Tulfo versus Court of Appeals, penned by Justice Presbiterio Velasco, and also in the case of Ayer Productions versus Capulong and Borjal versus Court of Appeals, this court has always said that a public officer cannot shun criticism. Is that not correct?
Yes, Your Honor.
Yes, and in fact, in U.S. versus Bustos, it said that officials, and in that case, it was a member of the judiciary, should not be too onion-skinned with respect to some criticism. Is that not correct?
You are very
Yes,
correct,
and
Your Honor.
as you go higher the ladder of positions in the public sphere, such as, for instance, when you become a member of the Supreme Court, or perhaps Senate President or House Speaker, and even the President of the Republic, you have to expect that the criticisms against you are going to be more, let us say, antagonistic, systematic sometimes, and even vociferous. Is that not correct?
Yes, Your Honor.
Yes, and any kind of a criticism, we have to be careful with respect to labeling it as a matter of destabilization. Is that not correct? For in truth and in fact, in this court, if there is a dissenting voice, and they write very strong dissents, in many of the cases here, that is considered simply as a dissent, opinion at the margins, but certainly not a destabilization effort. Is that not correct?
Especially this court, Your Honor.
Yes,
Never.
and therefore, I am a bit disturbed that the Solicitor General, the Tribune of the People, is considering the petitions that have been filed, which I find to be, perhaps it was difficult to prepare at the very least. Whether or not it will be granted by the court is another matter altogether, as part of a destabilization effort. Would you agree with me with that? Or do you keep to your position that this petition is part of a general destabilization effort against the Duterte administration?
I have mentioned that in my opening statement, Your Honor.
Okay. In any case, I just want to have expressed that. Okay. Next, the Solicitor General, of course, wants to protect the police. Is that not correct? As this court also wants to protect the men and women in uniform. Is that not correct?
I am the lawyer of the Republic of the Philippines
Yes.
and all its officers,
And of
Your
course,
Honor.
back of our minds is our concern for the ordinary PO1, up to the chief of the PNP, and I am very happy that the chief PNP has honored our invitation to come over. He has a very nice hairdo, and I would like to acknowledge that too. But we want to protect the men and women in uniform as well.
Yes,
this
Your
court,
Honor.
yes.
Definitely.
And that includes maybe 6 years from now, 7 years from now. when there will be changes in administration, we would want to know for sure that none of them will be the subject of suits because they have let us say, they have thought that certain actions that they have done is actually legal when apparently it is unconstitutional or illegal. Correct? You would want this court to be able to tell now the PNP that there are certain kinds of orders, certain kinds of police actions which may not be legitimate. Is that not correct?
Well, if there are those who violate the law, they should be punished, Your Honors.
Yes. And in other words, you would want this court to clearly come out with a decision on the allegations of the petitioners in order that in the future, they will say, the Supreme Court already said that this is illegal, this is legal, and therefore with what is legal, aggressively pursue the drug pushers, the drug manufacturers with that kind of an action. And of course, you would also want this court to say, etong bahagi na ito, baka hindi po pwede. So therefore, they would be at least advised so that 10 years from now, 20 years from now, they will feel protected. Is that not correct?
Well, the problem, Your Honor, is that the allegations in the petition are based on hearsay, Your Honor.
Yes,
not
but-
on their personal knowledge.
Yes, but you understand that the police are now being aggressive with respect to drug pushers and the manufacturers perhaps and the importers. And being aggressive, of course, means a lot of things. They put their lives on the line, and I acknowledge that, and I know that there are many heroes among the ranks of the police.
Yes, Your Honor.
Yes, but on the other hand, that in order to be able to deliver, there may be some that are already at the margins, doing some constitutional shortcuts, which will put them in danger in the future. Is that not correct?
It is the policy of this administration that it will not sanction any illegal acts done
Okay.
by any
That's nice
police
to know.
officers.
And
Your Honor.
therefore, wouldn't it be helpful for the police that this court already examines this CMC 2016-16, DILG 27-12, to say clearly, this one is all right, this one is not all right, in order to assist the men and women in uniform to give them more confidence so that they can be more aggressive to pursue the drug pushers.
As always, Your Honor, I submit to the collective wisdom of this honorable court.
Okay, thank you, Honorable Solgen, for that comment. Now, let me go to another point. I was affected by a article from the Times Magazine online, which showed pictures that affected photojournalists. We have lots of photojournalists on this issue. And there was a picture there of a man sitting next to a coffin, and the man had a Duterte band. I'm sorry, I didn't bring it with me. And the caption read that the photojournalist was so affected because that man was crying over a dead 7-year-old body of his daughter, who was raped and killed. Okay, most probably by a drug addict.
Yes, Your Honor.
Yes, and the photojournalist said, again, I forgot the name of the photojournalist who took the photo and got affected by it, that that in itself tries to explain to him the context of the support for an all-out war against illegal drugs. Okay, I was affected by it because, of course, whoever did that must not be within their right minds. But on the other hand, from another perspective, let me ask you this question. Can the police give this man a gun and tell this man, go ahead and kill the perpetrator? Is that a legal act?
The police cannot give guns to those who are not qualified to own and possess guns, Your Honor.
Supposing that man had a gun, can the police tell the man, go ahead, kill the perpetrator?
Well, I cannot make any judgment on that
That would be
hypothetical
illegal.
situation,
Yes,
Your Honor.
that would be illegal because it is a classic bar question where, of course, which probably will come out in the bar in the future, but would probably, in the far future, I will guarantee you that. But that would mean, therefore, that the police would be the enabler or the principal in terms of a crime of murder. Is that not correct? Anyway, that's
Well,
the point. Okay.
yes.
Now, can the police simply operate in order to kill? In other words, is any kill order just a kill order. Go after the drug addicts, kill them all. Is that an illegal order? Is that a legal order?
It would depend on the actual circumstances on,
No,
on
a
how...
general order. Go out, kill all the drug addicts, all the drug pushers. Is that a constitutionally valid order? I'm asking you
Well,
as
if
a
that is couched in in that language, Your Honor, it would be an invalid order.
invalid and unconstitutional because there has to be no person shall be deprived of life
Yes.
without due process of law, and that means circumstances will only allow the killing during police operations. Is that not correct?
Yes, Your Honor.
Yes. So therefore, a kill order by itself is unconstitutional. Would you agree with me? A general kill order, kill the drug addicts. It's like kill all the Negroes.
Who is
kill
the
all-
one ordering the killing, Your Honor?
If it's a public officer.
Public
that would be
officer
legal,
like
correct?
a police officer?
Okay, let me go to more specific questions. Is there a kill order from the president?
No, Your Honor.
None.
There's no kill order.
Is there a kill order from the executive secretary?
None.
None. Is
None,
there
Your
a
Honor.
kill order from the DILG secretary?
None, Your Honor.
Is there a kill order from the chief of the PNP?
He's here, Your Honor. You can ask him that later, Your Honor.
Yes. May I ask the PNP chief to come to you in the podium? I'll just ask 2 or 3 questions.
General Bato,
And,
please
If
proceed.
possible, kindly stand with him in order to be able to advise him. Good afternoon, Chief. Good afternoon, General.
Good afternoon, Your Honor.
Have you issued a kill order to your men and women?
Never, Your Honor.
Never. Have you said neutralize the drug addicts?
Neutralize, Your Honor, has a lot of meanings according to our police operational procedure.
Yes. Did you mean to kill when you said neutralize?
It means arrest, having the suspect surrender, or killing the suspect at a very, very extreme situation wherein as a result of legitimate police operations, there is a gunfight, then
Okay.
the killing may result, Your Honor.
General, you of course know that we are being live streamed. And what you're saying here is a communication to all men and women in all precincts at all levels. Therefore, you are actually saying you are not ordering them to kill
No, Your Honor.
drug addicts, drug pushers,
No, Your Honor.
importers, manufacturers,
No, Your Honor.
except under very extreme circumstances, which of course I will have to flesh out with the Solicitor General because he is more your legal expert. But
Yes,
you are
sir.
actually saying that. And never have you meant in any way whatsoever, by saying neutralize, you have never meant that the police is authorized to kill. Is that not correct?
Yes, it's correct, Your Honor.
What is correct?
That
You are on your oath as a police officer, correct?
yes, Your
Yes.
Honor.
And you are now telling your men that neutralize does not mean kill.
Yes, Your Honor.
Okay, thank you, General. Thank you also for the Solicitor General for allowing him to
Yes, Your
go with you in the podium.
Your wish is my command, Your Honor.
I doubt that because, it has to be the collective wish of the body. Okay. So, is it legal for the police or any law enforcement official to subcontract the killing of any persons of interest or suspect?
They are not in the construction business, Your Honor, so
Yes.
that's illegal.
In other words,
They cannot
it is
subcontract.
illegal for them to actually hire vigilantes or goons who are ununiformed to actually do the killing for them.
Yes, Your Honor.
It is not legal.
Not legal.
And anybody, any police officer caught doing that shall be subject to sanctions. The ultimate one, of course, would be murder. Is that not correct?
He will be investigated, and if guilty, he will be punished, Your Honor.
Okay. Is it illegal, is it legal for a police officer to kill a person simply because that person is a suspect in terms of drug pushing?
If those were the only facts, then it will be illegal, Your Honor.
Yes.
Unless
I'm sorry.
the police life is threatened.
Yes. I'm sorry, the Honorable Solgen, I have to clarify this because this is the confusion that is out there in the public. What is the real position of government? And here you are as the legal counsel of government to clarify all of this. And I am just eliciting this in relation to the petition because it's also related to the petition. And
Yes, Your Honor.
I am glad that you're answering forthrightly, clearly, that there is no legality for any kill order, there is no legality for subcontracting, etc. Okay, now, is it legal to kill just because the police action is legitimate?
Is it legal to kill,
Is
Your
it
Honor?
legal for the police to kill the person of interest simply because the police action is legitimate? Or is it only legal to kill, apart from the legitimacy of the police action, if the police are caught in a situation where self-defense is applicable?
The second one, Your Honor.
The
That's
second
legal.
one.
Yes.
That it is not the legality. In other words, they file all the forms, they get all the permissions, they coordinate with the PDEA, they are in uniform, they follow everything in the operations manual. That in itself is not authority for them to kill, correct? It is when the suspect actually does an unlawful aggression, according to self-defense, and in unlawful aggression, the only means to repel that unlawful aggression is to actually injure or maim the suspect. Am I not correct?
Yes, Your Honor. When an operation is declared legal operations, that means none of these criminal acts should happen, Your Honor.
Yes. In other words, it is not simply the fact that they filed the proper papers,
Yes.
but there has to be a situation of self-defense.
Yes, Your Honor.
Yes. And how is it that the police determine, the internal affairs units of the police determine that indeed there was self-defense?
There was self-defense.
Yes.
Well, they will report their operational activities, and if there is any complaint, we have the Internal Affairs Office of the PNP. In fact, the one in charge is here also.
Am I
court.
not correct in saying that the manuals that you have cited a while ago state that the crime scene is to be preserved in case of death of whether a police or a person of interest, so that the forensics teams can come in order to take note of the site, so that later on when there is a complaint, there is an evidence that can be presented. And isn't this contained in what is called a spot report? Am I correct? Am I accurate?
Well, Your Honor, the procedure is that if there is a death, normally there is a SOCO team,
Yes, the forensics.
scene of the crime
Yes,
operatives under the crime laboratory of the PNP, Your
yes.
Honor.
And they prepare a report.
And they will prepare their findings and report.
Yes, and that report, what is it called?
May I ask the
Yes, please.
Internal
Because-
Affairs, Your Honor, to enlighten this court about it?
Yes, can we ask the Internal Affairs officer?
Attorney Triambulo, for the record, please state your name and official circumstances.
I am Attorney Altigar Triambulo, the Inspector General of the Philippine Internal Affairs Service.
So, my question is, in case there is death in police operations, okay, and let us assume that it is death of a person of interest. I am careful because there is some contention regarding whether that person is a suspect or only a person of interest, or even an innocent bystander. What happens after that?
The Internal Affairs Service, Section 39 of Republic Act 8551 empowers the Internal Affairs to conduct motu proprio investigation in incident where death, serious physical injury, or any violation of human rights occur in the conduct of police operation.
Yes. Here is my problem. Police officers that are involved, for example, there is a situation where there is truly self-defense involved. So they are forced to draw their guns and shoot. And as a result of the shooting, the victim dies. And for that matter, when there is a charge against them, they will need evidence, correct?
Yes.
Yes.
Yes,
And for evidence to be present, the crime scene has to be investigated immediately, correct?
Yes, sir.
Yes. Yeah, and it cannot be touched. Therefore, after a police action, and there is a resulting death, whether it's the police or the victim, it is also for the protection of the police that there is a forensic done. I think it is done by the SOCO. Yes. And these forensics are going to be put on record. Is that not correct?
Yes, Your Honor.
And what is that record called?
The forensic examinations of the physical evidence taken from the crime scenes. Your
Yes. And is that available to the relatives of the victims in case they request?
Under the policy of the crime laboratory, PNP crime laboratory, only the requesting party, and that is the concerned police station who has the jurisdictions of the scene of the crime.
Under your present rules, considering that there are many complaints about, it's called extrajudicial killings, summary killings, made by several individuals in the public, numbering into the thousands, according to some newspaper reports. In spite of that, it is not made available to the victims and the victims' families.
Your Honor, that is also our problem in the conduct of our investigation because the SOCO will not provide us the forensic examination, no, because that is one of a vital document that we have to secure or evidence to be gathered in our conduct of motu proprio investigation.
Because, you know, attorney, many of those that are affected here, in terms of the numbers, are not from gated villages. They are not from, let us say, in Quezon City, they are not from Ayala Heights, they are from Payatas. They are not from La Vista, they are from Tatalon. Okay, and understandably, many of them cannot afford. And are you saying now that these documents are not made available to them?
I don't know, Your Honor, but insofar as the ES is concerned, we will first, when we receive a report that in a certain drug operations somebody is killed, the ES will immediately conduct motu proprio, identify the operatives who participated in that operation, interview the witness, secure all evidence of document, and then submit the fact-finding investigation to our pre-charge investigator for determination of probable cause. And then, of course, there is a homicide, the crime of homicide, but other from that crime committed, we also look to the possible violations of the operatives in the police operational procedure, as well as the lapses of the commanders, Your Honor.
Okay.
And then file charges, and then conduct a summary dismissal proceedings.
Okay. So I will not take the time of the Solgen. Just one more question. So for now, how many are being investigated since 2016?
Your Honor, from July 2016 to November 2017, the ES monitored and acted on 2,657 police operations, which resulted in the death of more or less 3,800 alleged drug personalities, regardless of its limitation in manpower, mobility, and logistics. As shown in the slide are the monthly action taken by the ES relative to status of drug operation cases. A total of 1,489 fact findings investigation were completed. 819 cases subjected to pre-charge investigation had been resolved, and 177 of the 321 cases subjected to summary dismissal proceeding were resolved already, Your Honor. And
Of the 177, how many cases
of the
were
177, Your Honor, the ES recommended penalty, there was a significant increase of the 159 cases resolved in 2017 2017 as compared to 18 cases in 2016. As the breakdown, Your Honor, as shown in the slides
I'm sorry, I
3,
didn't get it. So
total of
in 2016, it was 18 filed.
18 were found liable, Your Honor.
In 2017,
159, Your Honor.
so a total of
72, Your Honor. 20 operatives were dismissed. 31 were, 72 were dismissed. 20 were demoted. 31 were suspended. 2, the salary were forfeited, which give a total of 125.
Are any of those named in the petitions under investigation? Are any of the police officers named in the petition under investigation?
In the petition, Your Honor, we identified in some victims, Your Honor, mentioned in the petition, we identified the operatives, Your Honor, and their cases were already, some were subjected to summary dismissal proceeding. The other, Your Honor, that's where the IAS is still conducting fact-finding investigation to determine whether
So named in the petition, for
PNP is involved
instance,
in the
is a
killing.
certain police officer Alvarez, who introduced himself as Verdugo ng Delpan. According to the petitioner, is he under investigation already?
I cannot answer, Your Honor, because I
Okay.
did not have the list all the
Yes.
PNP personnel.
Kindly submit that to the court. But again, thank you, and again, I think if you will submit your statistics to the court, that would be very helpful, at least for determining whether or not we issue the reliefs that are being prayed for. Thank you, Attorney.
Thank you, Your
But may I ask the Solicitor General again, just so we go quickly. Again, pardon me for asking this question. Is it legal for police officers to have authorized funeral parlors for those that are victims of police actions and non-victims of police actions?
What I understand, Your Honor, is there is an accreditation process, not only by the PNP but the NBI, that must be accredited with these offices to maintain certain standards, Your Honor.
Okay, and it is not a single funeral parlor that is accredited. Am I not correct?
Well, I do not know the exact number, Your Honor, but there must be, these parlors should be accredited by the office concerned, like, even the NBI has accredited funeral parlors and PNP, but as to how many, Your Honor, I have no knowledge.
Based on the rules, who pays for the autopsy and the funeral arrangement? So these are two, the autopsy and the funeral arrangement of a person that has been killed in a police action.
May I consult our resource persons, Your Honor, so
Okay.
that I will answer you correctly, Your Honor?
Yes.
Your Honor, I have the answer.
Yes.
There is no payment for the autopsy.
Oh, really?
Unless there is a generous local official who will foot the bill, Your
So
Honor.
the local resident is not supposed to pay for the autopsy.
Yes, Your Honor.
And if they actually paid the autopsy to a police officer, that is illegal.
If what, Your Honor?
If they actually paid
To
the
the-
costs of the autopsy to a intermediary or to a police officer, That is illegal.
Well, it stands, Your Honor, that there is no payment in autopsy. But when the deceased will be buried, etc., he needs coffin, etc., then the relatives will pay for that, Your Honor.
Okay, and it is not legal for the police in a precinct to facilitate the funeral arrangement.
Well, I cannot answer for them on
Your
that
Honor,
matter,
the
Your Honor.
Honorable Solgen must understand that these are, as alleged in the petition, some of it, and of course, these are what's coming out in terms of unfortunately, the drug war. These are the incidents to it. That's why I want to clarify it from you now, because we have the public listening to us, and of course, in relation to the implementation of CMC 16-2016. So I understand from you that there is no payment.
Yes, Your Honor.
Yes, thank you. Okay, just to clarify, there is no authority for any police to ask for a consideration in order to dismiss a case or not forward the case for inquest. Am I correct?
Well, what is the first part of your question,
There is
Your
no
Honor?
authority for any police who, upon arresting any drug pusher, there is no authority for that policeman, or let me rephrase it, it is illegal for that policeman to ask for consideration in order not to go through inquest or in order to release the person arrested.
Definitely, Your Honor.
That's extortion, correct?
Yes, Your Honor.
That's a criminal act of the police, correct?
Yes, it
Yes.
is in the revised penal code, Your Honor.
And if it had happened in Payatas, in Station 6, for a sum of 20,000 pesos, that the police was asking in order that the person will not be brought to inquest, that would have been illegal, correct? I am asking a hypothetical
I'm not privy
question.
to that info, Your Honor, but if he did it, that's illegal, Your Honor.
Yes, and there is a mechanism, or is there a mechanism within the PNP where ordinary citizens can go in order to make a complaint above the police precinct? Because, you know, Mr. Solgen, having worked with some areas involving informal settlers and the urban poor, in their areas, the police station or the substation, they're gods. And therefore, they want to be able to get to somebody. Of course, they cannot reach Chief PNP Bato because he is too popular and so many people are surrounding the Chief PNP. Is there a unit where they can go in order to complain?
The Internal Affairs Service of the PNP, Your Honor.
Is it not the counterintelligence, CICT, if I'm not mistaken?
Well, the intelligence people, they have their own mandate, Your Honor, to
Yes.
gather information.
Yes, because the police has counterintelligence, and I understand that the President ordered General Bato to revive that mechanism in order that the police themselves do the policing of the policemen. Am I not correct? Anyway, perhaps you can cover that as part of your
Memorandum, Your Honor.
as part of your memoranda.
Yes, Your Honor.
In order for us to be very clear that there is this process. But certainly, it is not in the CMC order on Tokhang. Am I not correct?
It is not, Your Honor.
In fact, in the Tokhang, in the CMC 2016-16, there is a provision on internal cleansing. Am I not correct?
Yes, Your Honor.
But it is very brief. In fact, only one paragraph. Am I not correct?
Well, the shorter it is, the clearer it becomes, Your
Yes,
Honor.
but with respect to drug suspects, there is this entire procedure for Tokhang. Is there Tokhang for police who are corrupt? I'm sorry.
I'm
is
not
there
aware,
Tokhang
Your
for police who are open to these kinds of activities which I described? It is unfair to call some of the police corrupt unless there is a conviction. But some of the police, you must agree with me, because there have been convictions, there have been filing of cases already. There is no detailed process where there is a hangyo to the police to stop doing what they're doing in the CMC order. Am I not correct?
Well, it may not be couched in that in those terms, Your Honor, but definitely Tokhang, from its from the root meaning of Tokhang is Tok-Tok and Hangyo in the Cebuano dialect. It means nakikiusap.
Yes, but the police also have houses. They also have offices. And as a matter of fact, I overheard an interview by the chief PNP that he has committed even after retirement. I do not know if he understands what he was committing to. After retirement, he will still go against those that are wayward inside the PNP establishment. Am I not correct?
Well, personally, I've not heard him say that, Your Honor, but sometimes our chief, police chief, sometimes he's emotional at times, Your Honor, when he sees, the evil in this land. He wants to
Like all of
to
us.
protect those who are victims of the
Yes.
these illegal and illicit drugs, Your Honor.
But when you look at the CMC order, there seems to be a detailed process to go against the retail drug pushers through Tokhang. But there is no detailed process to go against the wayward police. As per the presentation of government, I think this happened in the De Lima case, that drugs has infected not only the local governments, but also the police establishment.
Yes,
So,
there
can
are
we
also
not say,
incidents, Your
therefore,
Honor.
that in the implementation of this CMC circular, that it can lead to certain unconstitutional acts because we are empowering the same policemen that are supposed to be also incarcerated or disciplined?
Let me answer your question first on the process in Tokhang, Your Honor.
Okay.
As I mentioned in my opening statement, it undergoes a 5-tiered validation process. And the process flow chart is something like this, Your Honor. The first is the source of information. And they gather this through sworn statements of victims, arrested suspects, intelligence operations, reports, etc. And then once this is finished, Your Honor, it goes to another level, the Barangay Anti-Drug Abuse Council, or BADAC, B-A-D-A-C, for verification. So contrary to what the petitioner said, that it is only the barangay chairman that will put names in the alleged list, that is not true, Your Honor. The Barangay Anti-Drug Abuse Council is the second tier in the process of validation. After BADAC, Your Honor, validates it, it goes to another third tier, which is either the MADAC or CADAC, meaning either the municipal or city anti-drug abuse council. And after this is processed here, it goes higher to the provincial validation workshop. And these are participated by PIB personnel, all station intelligence officers, representatives from PDEA, PDEU, and AFP. After this is validated on this level, it goes on a higher tier, the regional validation workshop. This is on quarterly basis participated by RID, Regional Intelligence Personnel, and all provincial intelligence officers, area command intel officers, etc., and representatives from PDEA, RDEU, AFP, NBI, and NICA. And the last validation in the process, Your Honor, is the National Validation Workshop. This is done on semi-annual basis, participated by the Director of Intelligence, Directorate for Intelligence personnel, all chiefs of the regional intelligence, etc., and the J2, ISAP, PDEA, NBI, and NICA. After it finishes this process, Your Honor, it cascades down to the station level, Your Honor. That's when they will undergo the Tokhang
Yes.
operation.
I understand.
Mark, can I just interject? May I request, is this the only PowerPoint presentation you're going to make before this court?
Yes,
Because I'll be also asking Attorney Triambulo, who earlier showed us data, and your team as well, to give a copy to the clerk of court right now so we can immediately rush and have them reproduced because basically we cannot see them.
Yes, Your Honor. I will,
If there's any other resource person who has a slide that will be presented later on, kindly please submit them to Attorney Anama now so she can have someone immediately reproduce them for the justices and also for petitioners. Thank you. Justice Leonen, my apologies.
Thank you. This is for the Tokhang persons of interest. My question actually was, is there a similar process for the internal cleansing? In other words, is there a list of police that are to be cleansed? And is that list also validated at all levels?
well, as the Chief of the Internal Affairs said, there is also such process, Your Honor.
Only
But
after there has
I'm
already
not
been
aware of
incident?
any flow chart. I have not seen any, but there is a process, Your Honor.
Okay. Let's go to the list. What is the process of getting out of the list?
Of the,
Out of that list? Supposing that a barangay submits, or at
Yes,
that
sir.
level, a name,
well,
and then it is
doesn't-
validated.
It doesn't start really from the barangay, Your Honor. It starts from, as I said, the source of the information processed
Yes.
by the police
Okay.
station.
Once the person is already in those lists as persons of interest, what is the process covered by the circular or the operations manuals? What is the process of getting out of that list?
Well, Your Honor, I was informed that the person of interest can seek a clearance if he's cleared, Your Honor. He will be given a clearance if his name is not in the list, or even if it is in the list, it was verified that it is not correct. He can ask for a clearance, Your Honor.
And where is that contained? Where is that process contained?
Can I ask General Coronel? It can be at the level of the station police, Your Honor.
Yes, no, my question is, where is it? What is the manual? Where is the provision? Or is this only discretionary on the part of the station commander, the chief PNP? Because there is an elaborate process of getting into the list, but I cannot find the process in writing to remove a person from the list.
Your Honor, actually this process flow chart is the validation itself. So if in the process these tiers will say that this guy should not be here in this list, then that is the validation, Your Honor.
Supposing the person actually finds out that he is in the list because there is tokhang that happened in his residence. That person, you mean, does not have a reference, or the lawyer of that person does not have any reference in order to tell them and inform them how to get out of that list. Because you know there is a presumption of innocence. And that person can say, I would like to get out of that list and prove to me that the evidence that you have deserves that I be put in that list.
Well, as I said, Your Honor, this is
So
a
there is none.
process itself in cleansing any...
From the police side, correct?
yes, Your Honor.
But from the side of the respondent,
Then,
isn't that a violation of due process of law?
no, Your Honor, because he's not being charged yet.
I hope that you can cover that in your memorandum.
Yes, Your Honor.
And clearly provide us with. Okay. Before perhaps I will just ask a few more questions from you, and then I yield to my colleagues. Who is in charge now? Is it the PNP or the PDEA? You see, I again heard the President say, yesterday in fact, that he is going to return the actual operations now to the police. But on the other
No,
hand,
Your
he did
Honor.
mention PDEA the month before.
The one in charge now is PDEA, Your Honor.
So what of that speech of our President?
Maybe he's thinking about it, but it has not yet
Yes.
been
So you are
operating, Your Honor.
you're admitting that it is possible that the police again will be in charge.
It depends on the decision of the President,
So it
Your
is
Honor.
capable of repetition.
Well, only a fool does not change his mind, Your Honor, so...
Yeah, okay. So it's capable of repetition, so it therefore is not moot and academic.
We will
simply
cross
because-
the bridge when we get there, Your Honor.
By the way, how many operatives does PDEA have?
May I
Yes.
ask information,
Just
Your
a
Honor?
ballpark figure.
PDEA has around 1,100 agents, Your Honor.
And the population of the Republic is about 100 million, correct?
I think so,
And
Your Honor.
The number of people that are supposed to be affected is close to millions also, correct? Yes.
Yes, Your Honor.
So now the drug war,
Actually, more than 1 million.
yes. So the aggressive drug war of the President now is given to a unit that only has 1,000 operatives, correct?
That shows, Your Honor, the President is sensitive to...
So
Public
if there
opinion.
is a true-blooded effort to try to get all the drug pushers, arrest them in order that they be prosecuted and hopefully convicted, then definitely this situation will not hold. That eventually the police are going to be involved. Am I correct?
That is a distinct possibility, Your Honor, considering there is only 1,200 PDEA agents. They cannot cope
Yes.
up with the 4 million drug addicts, Your Honor.
Again, that it is capable of repetition. Correct?
Well, hopefully, we will remove those unsavory aspects of it, Your Honor.
Okay. Again, my last question before I yield. If the CMC circular is declared as unconstitutional, the CMC circular by Chief PNP General Bato is declared as unconstitutional. There is this operating manual, Philippine National Police Manual, PNP MDO 214DO. This is revised PNP manual on anti-illegal drugs, operation and investigation. This survives, correct? This is not being questioned, correct?
It should survive, Your Honor.
Yes, and if we declare the CMC order as unconstitutional, the police can use this. Is that not correct?
Yes, Your Honor,
Yes.
because it has been proven that it works.
In fact, browsing through it, it has more detail on the protection of rights
Yes,
as
Your Honor.
compared with the CMC order, correct?
Yes, Your Honor, and therefore there is no basis
So
for that to be declared
it may not be correct
unconstitutional.
to say that when we declare the CMC order of General Bato as unconstitutional, that the intention is to stop the drug war. Because as a matter of fact, personally, yes, go after all the criminals, including the corrupt police, including the enablers, most especially the importers and the manufacturers. And I've said so in People versus Folgado as a statement that this court is now ready to accept prosecutions, convictions, not only of the small drug dealers of 0.01 grams, but also those that carry into our country kilos of shabu. So we are for that. And therefore, it may not be accurate, correct, to say that if we declare the CMC order as unconstitutional, the court is against going after drug pushers and drug enablers, correct?
However, Your Honor, in the Almora petition, they put in also the prohibition, and they're attacking the constitutionality of this CMC 2016.
Yes, precisely.
And,
It is declared as unconstitutional.
one of the prayers is that this court should direct the respondents, meaning to say the PNP and PIDEA and DILG, or any of their agents, representatives, or assigns, be prohibited from implementing or enforcing any instructions or command or utterances of President Duterte to the PNP and or DILG in relation to the war on drugs and anti-illegal drug campaign.
Okay.
How can that be possible, Your Honor?
Okay, perhaps just cover that in your memoranda to explain it more clearly. I guess your question is a way that you are answering my question.
Yes, Your Honor. Definitely
And
we will.
it is not for me to answer your question, although I am tempted to answer that. And finally, Your Honor, the Solicitor General, supposing there is an innocent bystander that is killed, let us say a baby, let us say a minor, that is killed in the crossfire. Is there liability on the part of the police that has conducted the operation for the death, the wrongful death of, let us say, a baby, a 5-year-old, a 6-year-old? Because certainly a 5 or 6-year-old cannot have criminal liability, you will agree with me. And therefore, for them to be victimized, and certainly a 5 or 6-year-old na nanlaban cannot be the unlawful aggression allowed under self-defense, correct? So, is there liability on the part of police officers for those where in the police operations they have actually wrongfully caused the death of a minor?
Is this an actual case, Your Honor?
No, in a hypothetically.
Well, again, I would say it depends on the circumstances during that incident, Your Honor. Because there is also such thing as justifying or exempting circumstances, Your Honor.
For the killing of a minor.
Well, for killing a person, Your Honor.
What is the
for the
just-
death of a person.
What is the
Under
exempting?
these circumstances, there was crossfire, Your Honor. We
Yes.
don't even know which bullet hit the child, Your Honor.
2.24 of the revised PNP manual on anti-illegal drugs. It says the team leader must see to it that all actions are in accordance with law, etc., and innocent people in the area of operations are ensured. That is a provision in the manual. Okay. In any case, I hope that you will also cover that in your memoranda to say that there is no impunity in terms of wrongful deaths that happen in the police operation, so that the court is clarified as
Yes,
to
Your
whether
Honor.
or not the existing manual as well as the current regulations are sufficient to protect citizens. Again, I will reiterate that this court stands in support, I speak for myself, I stand in support of any anti-criminal activity, but also that I stand in support of the Constitution, that there are protections that are given to every person, even those that are found to have committed a crime, because there is a right to due process, a presumption of innocence, and the right against self-incrimination. Thank you, Mr. Sol.
Yes, Your Honor. Thank you.
Justice Ardilesa.
Mr. Soldian, good afternoon.
Good afternoon, Your Honor.
Do you have your copy of CMC before you?
Yes, Your Honor.
Soldian, Mr. Soldian, let me go straight to the first stage that's on page 3.
Yes, Your Honor. I'm here.
On the collection and validation of information stage, it says here that the police will collect specific information on identity and criminal activities, documented, verified, accurate, with solid proofs, respecting, and then the CMC uses 3 words, suspected drug users,
I'm sorry, I got lost, Your Honor. What particular...
Well, I will repeat it. The first stage is the police will collect and validate specific information on identity, criminal activities, and should document and verify with accurate and solid proofs. Okay, drug participation of, and then it uses 3 terms. First, suspected drug users and pushers.
Are you quoting it, Your Honor?
I'm still quoting, I have no question yet. The second term it uses is target, each target. And it uses, again, the word, well, it uses 2 words. A suspect or a suspected drug user or a suspect, and target. Are the terms suspect and target synonyms?
Well, they're not exactly synonyms, Your Honor, but maybe there is some sort of a correlation there, Your Honor.
They're very near. I mean, there is a correlation.
Yes, Your Honor.
Now, you introduced the term person of interest.
Yes, Your Honor.
Is there any correlation between person of interest and suspect and or target?
I think there is also some sort of correlation there, Your Honor.
Okay. The first stage is, will you agree with me, what in police parlance is called case build-up?
Yes, Your Honor.
Yes. Now, I will give you a hypothetical, Mr. Soldian, in relation to the drop box complained of. This is the drop box of the DILG. So, suppose the drop box contains a piece of paper saying, Mr. A is a drug user. And then it says, check with Mr. B. Mr. B is a suki of Mr. A. Given that information, the case build-up will be something like this. The police operatives will look for, is there a person, Mr. B? Interview Mr. B. If Mr. B says, yes, indeed, I buy drugs from Mr. A, but please forgive me, I will turn confidential information. I'm willing to implicate him. Most probably, as a result of the case build-up, the police will probably do a buy-bust.
That's possible, Your Honor.
That's possible. And if there is a buy-bust and you do it in accordance with law, then the police gets its man. The suspect, the drug suspect, target, or person of interest is out of the street.
Yes, Your Honor.
Stage 1 is successful.
Yes, Your Honor.
I'll give you another hypothetical. The same piece of paper from the DILG drop box again says, Mr. A manufactures shabu in his home and in fact uses it as a drug den. And then it says, check with Mr. C. Mr. C is one of the employees of Mr. A, and he can testify to the drug manufacture and the maintenance of a drug den. Assume again, in the case build-up, the police talk to Mr. C, they are, in police parlance, able to flip him, he cooperates, he is willing to execute an affidavit. And then when you have, the police have the affidavit, they will most probably go to a judge to ask for either warrant of arrest or a search warrant.
Yes, Your Honor.
In that case, again, stage 1 is successful.
That's right, Your
The
Honor.
build-up results in a drug manufacturer or maintainer, but then off the streets.
Yes, Your Honor.
But suppose, Mr. Solgen, the tips, the turn of events will be such that when the police interview the alleged customer, Mr. B, there is even no such person as Mr. B. Or there is a person, Mr. B, but he says, I don't know what that tip is all about. You know. So you cannot have a buy-bust, right?
Yes, Your Honor, because there's no one to pinpoint the the culprit, Your Honor.
So you're back to square one. You have Mr. A, he is in the list, he is a suspect, he is a target, he is a person of interest, but no probable cause, right?
Yes, Your Honor.
In the same manner, in the same hypothetical, the alleged status of A as a drug manufacturer or maintainer will not wash if the alleged witness identified in the piece of paper does not exist or he denies being a witness, right?
If there are no witnesses or evidence, Your Honor,
In which
then-
case, despite the case build up, you're back to square one, right?
Yes, Your
All
Honor.
you have is a suspect, also known as a target, also known as a person of interest. That is where stage one ends. Now, what is very conspicuous, though, with stage one is that it says on page 4 that you are doing all of this, you are doing the build-up, and I refer you to the last 2 lines in the first paragraph on top of page 4. You are doing the case build-up for the purpose of, and I quote, confronting suspects during house-to-house visitations, end of quote.
Is this in the topmost paragraph or the...
Yes, at the top paragraph, Mr. Solgen.
Well, it says here, Your Honor, that there was verification in all possible sources to equip the team with accurate and solid proofs when confronting suspects during house-to-house visitations.
Yes.
So-
Again, I stress, you have a build-up to enable you to confront the suspect during the house-to-house visitation.
well, to probably identify who are these persons, Your Honor.
Yes. But in the hypotheticals that I gave you, if the case build-up is successful, you either have a buy-bust or you successfully, or the police will successfully be able to secure a warrant. But I now bring your attention, if there is no evidence that will justify a buy-bust or a search warrant, then you have a case where you have a suspect, but you have no probable cause.
Your Honor, This command memorandum circular, or CMC 16-2016, applies to Tokhang projects and not buy-bust operations, Your Honor.
Yes, I know. I'm just stressing to you that the build-up, if successful, could result in a buy-bust. And in case of a buy-bust, you don't need to visit the house because the suspect will be in jail, right? What
Yes,
I'm
Your Honor.
stressing is if your stage 1 is successful, meaning the confidential information from the Dropbox results in a buy-bust, or number 2, results in a search warrant or an arrest warrant, it is successful. You don't need to visit the
Yes, Your Honor.
suspect.
Yes, Your Honor. Yes.
He will be held non-bailable, most probably. Right?
Correct, Your Honor.
Now, so I am now in the situation where, because there is no probable cause, no buy-bust happened, no search warrant or arrest warrant was issued. This is what I call, you're back to square one. You have a suspect. But then you go to stage 2. You have a suspect. There was no buy-bust. There was no warrant. Stage 2 now, you have a suspect. Stage 2, the police now coordinates with all of these agencies. But remember, at that point, you just have a suspect, right? But you already coordinate. Now, and then we go to stage 3, which, as the CMC says, is the highlight of Project Tokhang. The house-to-house visitation is the highlight of Project Tokhang. And I agree with you with the purposive use of highlight. Because in all of the previous house-to-house visitation, this house-to-house visitation is the distinctive feature of CMC 16, right?
Yes, Your Honor, because it it is like a bayanihan spirit in a certain place in barangay. The barangay captains, chairman, and the other persons there assist the police during this stage, Your Honor.
Yes.
of
Now,
Operation
I go
Tokhang.
now, I'm very near my question now. Stage 3, house-to-house visitation. The operations team leaves the police station. It is led by a PCO, that's a
Not asked to come in.
Oh.
They will just talk to the one who opened the door concerning this person, that the person of interest, if he's around.
Well, okay, you say that as in operation, they will knock
Yes, Your Honor.
and use the doorbell. But when the door is opened, they will not come in?
They will not come in, Your Honor, unless the owner invites them to come in.
Okay. Whether, but if they are asked to come in, they will come in.
In certain occasions, maybe, but not all, Your Honor.
Not all. If they are asked, can you stay outside the door, they will stay outside the door.
Yes, Your Honor, because
The process was such that it did not result in a buy-bust operation or in a warrant search. That is why you have the knock on the door, right?
maybe, Your Honor, the person of interest is not a pusher or a drug manufacturer, but is just a user, Your Honor.
Well, again, in the case build up, I would assume it is identified whether he is a user, he is a buyer, he is a maintainer of a drug, he is a manufacturer, right? Whichever. Now, so whichever is his category, And wherever are the police, at the door, or they were asked to go inside? This is now my question, which has got to do with the constitutionality of Section 3, Stage 3, the house-to-house visitation.
So,
That situation, Mr. Soljan, and you now as representing the government, isn't that a custodial investigation which triggers the obligation of the police to warn the suspect or the person of interest that before he even answers any question, he has the right to a lawyer?
well, actually, Your Honor, he's not there to be arrested. The police and the other barangay officials and citizens in that barangay accompany the police. This is not a purely police operation. And they knock on the door just to send a message that, you know, if he's into drugs, we have rehabilitation centers. Or if they want to change a new leaf in their life, they can cooperate, Your Honor. But the police never coerces them.
Mr. Soljan, that is why I called your attention in Stage 1, and I'm quoting from the CMC itself. The avowed purpose of the case build-up under Stage 1 is, and again I quote, to confront suspects during house-to-house visitations, end of quote.
Well, maybe there's, it's just a matter of saying, Your Honor. The word confront may mean to ask him if he's engaged in these activities.
Now,
And if he says no, then the police will just go to the next door that they will knock again.
do you maintain as the position of the government that at that point in time, there is no custodial investigation as defined by the Constitution or by statute?
There is no violation of that right, Your Honor, because the right of persons under custodial investigation can only be invoked when the person is taken into actual custody, Your Honor.
How about Republic Act 7438, Mr. Soljan?
Yes, Your Honor.
Do you see anything in RA 7438 which will make that visit or not custodial investigation?
I believe, Your Honor, under Section 2 of RA 7438, this will apply only when the person is actually arrested, detained, or under custodial investigation. None of these incidents happened in your hypothetical question, Your Honor.
I'm sorry, Mr. Soljan, I forgot to note the number of the provision. Can you tell me, there is a provision that has to do, and I quote, custodial investigation shall include the practice of issuing an invitation, close quote, to a person who is investigated in connection with an offense he is suspected to have committed, end of quote. Can you help me out? What is the number of the section?
Well, it's in Section 2, Your Honor, rights of persons arrested, detained, or under custodial investigation.
So again, Mr. Soljan, the Congress in 7438 has made what in constitutional law we call a legislative finding of fact. The Congress recognized when they enacted 7438 that there is such a practice of the police or of investigators of inviting persons who are in connection with an offense he is suspected to have been connected. And having declared or recognized that there is such a practice, the Congress defined that invitation to be covered by the term custodial investigation. And the effect is you cannot invite unless you give him, you read the person his Miranda rights. Right?
Yes, but in the Project Tokhang, Your Honor, the person of interest is not actually invited by the police to the police station.
I will go to that.
Yes, Your Honor.
In the context of the Miranda rulings and the constitutional prohibition, in the classical definition of custodial invitation, custodial investigation, the suspect is invited to where? The police invite the person to go where?
Well, normally in the police station.
In the police station.
Yes.
And Miranda was all about the coercive effects of being in a police station. It's the headquarters, you see policemen around, you are in a room, you are alone. That is why you need a lawyer, right?
Under the Miranda doctrine, yes. But here, Your Honor, Project Tokhang.
Not only under the Miranda ruling, but under the Philippine Constitution, as we have adopted Miranda, and 7438, right? Because 7438 even provides for criminal sanctions against persons who violate the custodial investigation rights of a person, right? And I go now to my question.
Okay.
I submit to you, Mr. Soldian, as lawyer of the government, when the police under Project Tokhang knock on the door, effectively, they have invited themselves into the home of the suspect, and that is a violation of the definition of custodial investigation. If the police cannot invite you to the station, the police cannot, under the same circumstances, invite themselves into your home.
Definitely, the police will not ask to be invited inside, Your Honor.
I am saying, Mr. Counsel, that as a matter of constitutional law, the Section 3 of the CMC is crafted in such a manner that it violates Section 2 of Republic Act 7438. Although literally, they are not inviting the person to the police station, effectively, the police, I don't know, 5, have effectively invited themselves into the home, and that has the same coercive effect. Because you're now talking to 10 policemen, 5, whether outside your door or inside in your living room. The other way I will put it, Mr. Counsel, is effectively, it is a violation of Section 2 because you have effectively, under Stage 3, transferred the police station to the house. That's the practical effect. The coercive effect of the station, literally you're not inviting to the station, but when you bring 10 policemen to the home, the coercive effect is the same, especially if it is done in the evening, especially if it is done beyond midnight, especially if it is done in the wee hours of the morning. So I said I am concerned about this stage 3. And to my mind, that's a violation of the rights of the suspect, or if you call him the target, or you call him the person of interest, of his right against self-incrimination.
With all due respect, Your Honor, I respect your view, but we will just discuss this in our memorandum, Your Honor.
Now, let me go one final point. The same procedure violates also the rights of the person, the suspect, under the Bill of Rights, Section 2. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature, and for any purpose shall be inviolable. That is why I took great lengths to walk you through your case build-up. Your case build-up to violate, to make an intrusion into the home, a reasonable search or seizure under the Bill of Rights. There is the intervention of a judicial officer, not a police officer, but a judicial officer. There is probable cause to issue a search warrant. Under stage 3, despite the case build-up, there is not sufficient evidence to justify a finding of probable cause. So there is no intervention of a judicial officer. Effectively, to my mind, what stage 3 does is to substitute the intervention of a judicial officer as required by the Constitution with the discretion of a police officer. Effectively, the person is not secure in his house for any purpose, and the avowed purpose, which is to confront, or even if I accept your formulation, the avowed purpose of which is to persuade the person to stop his evil ways, is not a purpose allowed under the Bill of Rights. For which reasons, Mr. Soldian, to my mind, and not examining the mass of facts presented by both petitioners, it seems to me there is prima facie case to issue a TRO against Section 3. Only Section 3, Stage 3, the provisions on house-to-house visitation of CMC.
May I respond, Your Honor? Under Section 3B, Your Honor, it states here, it states that the designated team leader shall ensure the presence of members of the provincial PADAC, KADAC, MADAC, or BADAC, as the case may be, and Barangay Tanod to assist them and to serve as witnesses in the conduct of house-to-house visitation. So this is not a purely police intervention, as you said, Your Honor. And I beg to differ my opinion from yours, Your Honor, and we will just discuss this in our memorandum, Your Honor.
Thank you, Mr. Soldian.
Thank you,
That
Your
will be all, Chief.
It's now 5 o'clock, so we will adjourn for today. We will resume the oral arguments on next Tuesday at 2 p.m. We request
Tuesday.
the PNP chief and the chief of the Internal Affairs Service and the chief of PDEA to please attend the next oral argument this Tuesday at 2 p.m. All the other invited resource persons are excused from attending the next oral argument. If there are no more questions, we adjourn for the day. Thank you.
Thank you, Your Honors.